Hello, my name is Ebony Leake, and this is my video recording of my presentation on my paper on the analysis of the excessive use of force in policing for my American policing course. So, more often, citizens are recording and reporting incidents of the excessive use of force by police. Therefore, it's necessary to investigate what internal and external factors encourage the selection of excessive use of force rather than choosing de-escalation, for example. A recent news article in the Wall Street Journal highlights both the skyrocketing cost of police misconduct cases and the growing public distrust of the use of force decisions made by police officers. So in this paper, I intend to reveal the impact of use of force training in the field and identify factors that influence the selection of the use of force and address ways that legislation might be able to influence the selection of use of force, especially excessive force in the field. In meeting the goals of this paper, it will be necessary to first lay out police training as it relates to the use of force and de-escalation and compare it to the application out in the field. Then I will provide an analysis of factors that regulate and contribute to the continued use of excessive force and other solutions, as well as to suggest future steps to try to curtail the excessive use of force. So I reviewed literature to determine the basic question that comes to mind. Are police trained in use of force? And well, the answer is yes, they are. Although training guidelines do differ from the training academy to when the officer actually makes it to their department where they will be working. So they don't always match from a training academy to department. So although police are authorized to use force, the basic idea is that police can and should only use as much force as necessary to overcome the resistance offered by the subject. It's basically a stepwise progression in which the officer uses the next more severe form of force only if the previous form of force did not induce compliance. The first step, for example, is just simply having the presence of the police. Then it goes through verbalization, hands-on techniques, compliance holds. The last option in that continuum is the use of deadly force. So one study found that there were 123 different variations of force continua throughout precincts in the United States. Some of that flexibility is there so that the police have the wherewithal to make decisions because their perceptions may be different in various situations depending on the conditions. So, although police are authorized to use this force, they are not legally allowed to use force in an excessive manner. As explained by the U.S. Supreme Court in Graham versus Connor, force must be objectively reasonable in view of all the facts and circumstances of each particular case. So they're only supposed to apply as much force as necessary to overcome subject resistance. Most agencies do not actually incorporate elements of citizen resistance in that continuum of force, nor do they incorporate factors such as the age of the subject or the skill of the subject, the size of the subject, or if backup is available. Those things are not necessarily incorporated into that continuum of force. However, it's important to note at the same time that up to 80% of officers are assaulted in the line of duty, and these officers are assaulted on an average of 7 times over their career. So it makes sense that training in police academies tends to focus on firearms and the use of deadly force. This is attested to the fact that 60 hours of this training currently accounts for the single largest share of pre-service academy expenses. And this level of attention reflects the fact that police officers are most often slain by assailants who are armed with firearms. Despite that, still police departments, many of them are trying to incorporate other alternatives. So many police officers are incorporating things like de-escalation training, procedural justice training, stress response training in order to regulate the response in very tense situations. Those options were very well received. It's just that many officers note that it's hard to translate what they learn from those kinds of trainings into real world situations, especially critical situations. So looking at the results, and beginning the research for this, I expected to find, that there was uniform training procedures for use of force, and that there would be equal time spent on each of those portions of that use of force spectrum. I also expected to find that, that there were very many police officers engaging in excessive use of force, compared to what you're seeing, on little clips and on television of excessive force. I also expected that it was that the police leadership was turning a blind eye to excessive use of force, or that they were just complacent. What we found, in fact, I found is that most of those things were not the case. So let's get into the results. So what I did find, as already stated, there isn't a uniform policy in use of force in terms of especially the response that the subject or offender poses. So that isn't present, that there is a great variety in the use of force, and even in what types of non-lethal weapons are available, there's variety there as well. So aside from that, what I found from my research is that unnecessary force is usually a training problem. Research shows that younger officers are more likely to use force than your more experienced ones. And your less experienced officers, likewise, are also less likely to use force than your more experienced ones. So in most cases, the use of force is rare. In fact, according to the Christopher Commission report of the Los Angeles Police Department, 5% of officers accounted for 20% of use of force reports. This is a potentially useful research finding because it suggests that if a department wishes to address the use of force issue, it's necessary to focus on that small group of officers. Now, there are some things that I found in the course of my research that make that a little bit difficult. One is that under prevailing judicial precedent, all uses of force must be judged as objectively reasonable based on the totality of circumstances viewed through the lens of another officer in the field. And for a jury to find an officer guilty of using excessive force, it requires a strict form of intent. They have to prove that the officer was using that excessive force on purpose and that it was not objectively reasonable. Moreover, sometimes juries are instructed to seek a finding of reckless disregard, where just the officer was completely abandoning all guidelines and standard procedure and reason. Furthermore, what we find is that qualified immunity has shielded frequently many officers from liability when the law was not clearly established at that time. So these things make it very difficult to hold a specific officer accountable for their actions. A plaintiff alleging that an officer has used excessive force usually does not get to make it in front of the jury because the defendant officer will make a motion for summary judgment based on qualified immunity. And many times the courts tend to be pro-defendant if that defendant is an officer. And so again, that doesn't make it in front of a jury. The other thing that I noticed is that unions have a very powerful influence and make it difficult for leaders. This is the part I didn't know, for leaders to actually be able to sanction officers or fire officers. For example, the Department of Justice consent decrees aimed at reform of police departments often include language that provides that any reforms can only occur to the extent that they do not conflict with the union contract. And so those provisions can delay or permanently hinder any reform efforts. Many of these protections under the union exist as a matter of state law. So it's even elimination of the police union or the contract wouldn't immediately change the law unless that statute happened to be repealed. The Chicago Police Academy Task Force actually said that the collective bargaining agreements between the police unions and the city have essentially turned the code of silence into official policy. So moving forward, trying to look at ways to curtail the excessive use of force. The Congressional Research Service, they identified that fact that there was not a uniform look at use of force in that spectrum, that continuum of force. And so they proposed to Congress that there be a force continuum or a force matrix, that be legislated by Congress. They often also emphasize de-escalation and the requirement of warnings, especially warnings before the use of lethal force. Congress has proposed 2 laws, the George Floyd Justice and Policing Act, as well as the Justice Act. Both of these laws, they're quite similar. They're proposed at different times, but essentially they want to ban the use of chokeholds unless deadly force is warranted. And then, of course, since they need to establish what deadly force is, they require the Attorney General to actually specify situations that would warrant the use of deadly force. At the same time, they're also requiring warnings, and also that all non-lethal means be tried before an officer resorts to deadly force. So I look forward to seeing, what comes of those laws that have been proposed and what changes may be on the horizon. I've really enjoyed this research project, and I hope that you also all will enjoy my paper. I've learned a lot in the course of this. Thank you so much.